I think we're ready to go. Again, good morning. My name is Chris Kempton. I am the director of the employee, our benefits consulting group here at Walsh Stuffield Companies. And today we're hosting a webinar that is titled New York State Enacts Statewide Paid Sick Leave Law. It's quite the mouthful here. This will be presented by Frank Kerbein, and Frank is with the Business Council of New York State. We know that this is a very important topic for employer groups right now, given the fact that many pieces of the legislation are scheduled to go into effect by the end of the month. And unfortunately, there's been very little guidance produced by the state of New York. So we're happy to have Frank here, and he interacts very closely with Albany, and he has information that will hopefully provide some guidance as we move forward. Before I introduce Frank, I'd like to cover some housekeeping items. This webinar is going to be recorded, so if anybody would like to have access to this recording, we will make that available to you. Frank has slides, and he will make the slides available as well. And again, you'll have to let us know. We can push those slides out to you if you are interested. There is a Q&A box. We're anticipating lots of questions. So there is a Q&A box that you can type in your questions, and then Rebecca on the Walsh Stuffield team is going to manage those questions, and at the end of the presentation, he'll push those questions right out to Frank, and Frank will do what he can to answer those questions for you. Again, I'm happy to introduce Frank today. Frank is the director of the Center for Human Resources at the Business Council of New York State. And again, when he's not presenting to seminars and webinars like ours today, he spends much of his time in Albany. He's lobbying on behalf of businesses in New York State. And he tries to understand the ins and outs of the New York State legislation. If folks here, companies are not members of the New York State Business Council, we encourage you to join. It does require an annual dues. It's modest, but it does help support the lobbying efforts that are very important to companies of the state of New York. This time, I'm going to hand the floor over to Frank and begin the presentation. Frank.
All right. Thanks, Chris. Appreciate it. Always a pleasure to work with Walsh to try to push this information out to as many people as possible. Thanks for joining us this morning. We hope we can answer all or most of your questions. As Chris mentioned, I'm part of the Business Council. The Business Council is the New York State Chamber of Commerce, if you want to think of it that way. We are the largest statewide business advocacy organization in New York State. We have some of the biggest companies in the world as members. We also have 60% of our members have fewer than 50 employees. So I have sort of a dual role with the Business Council. I am a lobbyist, as Chris mentioned, where I always like to say the good kind, not the kind you read about, that we advocate on behalf of business in a very challenging political environment in Albany. We have 7 in-house lobbyists who have different areas of expertise. We have environment, tax, transportation, manufacturing. The smartest group of people I ever worked with. As members of the Business Council, you have access to them on any one of those topics, and they can get you up to speed as to what's going on and how those areas impact your business. Because of our position in Albany, we're sort of the go-to for the regulators, for the legislature, for the governor's office. When they want input from business, they come to us. We typically get regulations and guidance before they're published to the general public for their input. We do that on a regular basis. They don't always listen to us, but when they do, we've been able to make some significant changes. And I'll actually talk about those in the paid sick leave law in a little bit. I'm not an attorney. I always have that disclaimer. So if you say Frank said it was okay, I'll deny it. And there are times here when I'll actually tell you need to talk to your labor attorney about this. Oh, I got a couple of quick things. I always like to put headlines in before we get to paid sick leave. When I put paid family leave in because remember the good old days when paid family leave was all we had to worry about? I wanted everybody to know that the paid family leave benefit level and employee contributions have gone up for 2021. Those numbers were released by the Department of Financial Services and are on the slides here. I also want to spend 2 seconds on the payroll tax holiday. As you know, the President Trump signed an executive order in August allowing employees to defer part of their payroll tax, the 6.2% you pay as part of the payroll tax. If for those who are in need at the last quarter of 2020 because of the COVID. However, there's a lot of, the IRS issued guidance on this, and we as the Business Council don't see this as something that employers might want to be jumping into. It's optional, and it's at the election of the employer. No obligation for employers to post a notice to employees one way or the other whether you participate or not. It's only deferred. The 6.2% is not paid for the last quarter of 2020, but it's added on to what they owe in the first quarter of 2021. So employees who defer now would be paying 12.4% instead of 6.2% in the coming year. And it only applies to certain people making certain income levels. Overall, we don't know many employers who have taken advantage of this. I haven't heard of any personally. And it's something that we would probably not encourage employers to jump into. The main issue is that employers are on the hook for this deferral for the ultimate payment of these taxes. If you defer for an employee for the last quarter of 2020 and they leave your employee, you're obligated to make up that 6.2% that was deferred. And one last thing, if you're a client of the state insurance fund, you get your workers' compensation from there. You get $500 for them to cover the cost of masks, gowns, gloves, goggles, hand sanitizers, any other COVID-19 related safety items. You can go to their website and get this credit up to $500 off your premium for 2021. So anyway, I wanted to cover those quickly just because I didn't want you to think we were ignoring them. Paid sick leave. As you remember, back when the budget was passed around April 1st, the governor, the legislature, and the governor passed, and the governor signed a new paid sick leave bill. This is independent of COVID. This has nothing to do with COVID. This is a new mandate on employers to provide a minimum amount of paid sick leave to employees for use. This was our first year in Albany with a one-party rule where we had Democratic control of the Senate, the Assembly, and the governor. There was a very progressive agenda put forth by the legislature. COVID interrupted a lot of that. But this was a program that was important to legislature and got through. It's effective September 30th. That's because it's effective 180 days after the governor signed it. And we'll talk about what that means. Employees can begin to accrue paid sick leave effective September 30th, and they can use this leave beginning 1/1/21. Employers may choose to front load paid sick leave. We'll talk about that in a minute, about how you accrual versus loading and how that's used. So how much do I have to offer? If I'm an employer that has 4 or fewer employees with less than $1 million in net income, I only have to provide 40 hours of job protected, unpaid sick time. If I have 4 or fewer employees and more than $1 million in net income, I have to provide the same 40 hours, but paid sick leave. The vast majority of employers in New York State fall in the 5 to 99 category. If you have 5 to 99 employees, you have to offer 40 hours of paid sick time. If you have 100 or more employees, 56 hours of paid sick leave. In Albany, the legislature, the governor, the Department of Labor, all think everybody works 8-hour days, 5 days a week, Monday through Friday. So things are always in 40 hours, 56-hour increments. They're thinking 5 and 7 days in their mind. But this is an hour accrual. So for instance, at the Business Council, we work a 37.5-hour work week. I would be getting 40 hours of paid sick leave at a minimum, and would have so in a sense would have 5 days plus a little extra. So it's not days, it's hours that we're accruing. I skipped right over the most important bullet on this slide, and that is the first one, that we are awaiting New York State Department of Labor guidance. In the statute that was passed, it says that the commissioner will have the Department of Labor will have the ability to write regulations and guidance necessary to implement this law. And that's typically what happens. The law passes, you remember paid family leave passing, and then we all waited on the guidance for that. That came in the form of regulations in that case. We've been asking the Department of Labor constantly since April 1st when the guidance would be coming. At the beginning of August, they told us there will be guidance and that it will be available in a couple of weeks. It is now September 10th. We picked this date because we felt safe that it would be the guidance would be available from the Department of Labor, and it is not. There has not been guidance proposed at this time. As Chris mentioned, I talked to the Department of Labor a lot, and I've talked to the General Counsel's office, the people who are writing this guidance. They answer my questions all the time. They're very helpful, I have to say, dealing with the DOL's General Counsel. We have a great relationship with them. But since the middle of August, we have had radio silence on this. They don't even respond to our inquiries. They respond to everything else. I could send them an email with 3 questions. They'll answer 2 of the 3, and they won't answer the paid sick leave question. The Department of Labor, as you know, by reading the papers, is inundated with the unemployment insurance system. It's all hands on deck to try to get claims paid. And I think a lot of the daily functions have sort of fallen by the wayside. But we expect guidance soon. It can't be in the form of regulations now because it's too late. There's a process for doing that. It has to be published in the state register. There has to be a comment period, et cetera. So it'll be in the form of guidance. They'll give us some of their thoughts as to what they think the law means. But we don't have that now. And when we get it is a big question mark. And it's really, to me, unacceptable that they haven't provided it at this time. So I'll mention as we go through these slides on a couple of occasions where guidance I think is going to be helpful, where it might come. But in the meantime, we'll deal with what we know. So we'll go through the basics. What can we use paid family leave for, and who is a family member? Some of you may know, New York City has had a paid sick leave requirement in place since 2014. And that law is so broadly written and so broadly defined in terms of what an employee can use it for, and so broadly defined as to what a family member is. For example, anyone who is like family is listed as one of the definitions of family member, that employers have a very difficult time in New York City complying with the law, and there are tens of thousands of violations issued every year to employers, not because they're not paying the time correctly, but because they're misinterpreting what the eligible uses are and what a family member is. Or New York City has additional requirements regarding postings and notifications that we don't have. So our goal in the legislative process this past spring was to make sure that whatever law was coming, and it was obvious this paid sick leave was coming, was functional for employers, right? That we defined clearly and limit what the uses are and what family member means. And I think we were pretty successful in that. Eligible uses, obviously, to care for I'm the employee, my own mental or physical illness or injury or health condition, for the diagnosis or care of medical issues, or for those of a family member. In addition, they added absences related to domestic violence, sexual offenses, stalking, and or human trafficking. So again, it's a longer list than you probably have listed in your policy that employees can use this for. But not as bad as it could have been in terms of reasons for use. Family member is also defined pretty narrowly. It's child, spouse, domestic partner, parent, sibling, grandchildren, and grandparents. I've become a grandfather since we last spoke, and I tell everybody that. And if my grandchild were in need of a diagnosis or medical care, I would be able to use my company's paid sick leave time to care for that grandchild. So again, not the broadest definition that could have been there, and it was, I think, pretty successfully narrowed down. Your policies are going to have to reflect this. When this was passed, the governor's office, the legislatures, we tried to work with them. Most of it, they would say frequently that most employers already provide this. What's the big deal? And my answer is, well, I agree. Most employers, you probably already provide a benefit that's at least this generous in time off. Maybe you don't, it's new, but most do. But every employer is going to have to rewrite their policy as a result of this statute. And there's a cost and an administrative burden to doing that. Everyone, I think, is going to have to rewrite their policy to reflect the reasons for use and the definition of family member. We'll get into some more considerations for your policy in a minute. We can set the reasonable minimum increments for use not to exceed 4 hours. So what does that mean? What they want is they want individuals who earn time to be able to use it. So at 1 hour for every 30 hours worked, once I get my first hour, I should be able to use an hour at a time. What they say is we can set the minimum increment as long as it's not more than 4 hours. So we can't say paid sick leave has to be taken in 8-hour increments, right? A key provision of this is that unused sick leave shall be carried over into the following calendar year. Your policy may or may not allow the carryover sick time. Now this mandated sick time is required to be carried over. We'll talk in a minute about paid time off policies and how all this will jive. We are prohibited from discriminating against or taking retaliatory action against employees exercise their rights under this law. Remember, this is job protected leave, so they are to be restored to their same position at the same pay and other terms and conditions of employment. We'll talk a little bit more about that in a second as well. So what if the law allows employers with leave policies to provide the amount of sick time, they're not required to provide additional time. So if the Business Council already provides 40 hours of paid sick leave, this is not an additional 40 hours on top of that, right? If I already offer my employees 40 hours of sick leave, and that's what the new statute requires I offer, this isn't additional time. As long as I'm already offering that and I meet the accrual, use, and carryover requirements of the statute, I do not need to offer additional time. Employees, we don't have a posting requirement for this, right? There's no poster, but upon request, employers are required to provide to employees a summary of their sick leave accrued and used both in this year and in previous calendar year. So beginning next year, we're going to do a better job of keeping track of time used and accruals. Doesn't have to be on the pay stub. We don't have to provide this proactively to employees at the first of the year. There's no requirement of that, only upon request of the employee. But we have to provide it in writing and within 3 days of their asking. There's no requirement that we pay out this mandated paid sick leave upon separation. Many of you have policies that allow for the payout of unused sick leave at termination. That's great. Some of you don't. That's also great. To me, this is a new mandate. And I always I get a little bit of an uncomfortable feeling paying out leave that's been forced upon me. I don't mind paying out unpaid sick leave if it was something we did voluntarily as an organizational decision to try to retain employees. That's fine. I get a different feeling when it's something that's mandated upon me. So you'll have to think as an organization whether or not you want to continue to pay out unused sick time at separation. If you're going to do this, include it in your policy. Don't leave our policies silent on this. A lot of times I'll hear that we have a sick leave policy, but it doesn't say if we pay it out. We used to, we have done it. I remember times when we didn't do it. That's when we get in trouble because then it appears we're arbitrarily applying our policy. So let's put that part in writing. This preempts all municipal sick leave ordinances in cities with less than 1 million in population, so that it's only New York City. So if you live in a municipality, and there were a few around the state that tried to or have implemented their own paid sick leave, this now preempts that. New York City gets to continue as is. They'll probably modify theirs because they don't have a 56-hour threshold. They'll probably add that in. And it's a payroll operation, so we have to maintain 6 years of records regarding paid sick leave, what we provided, what they accrued, what they used. It's going to be part of our regular payroll record keeping system. Talk to your payroll company if you haven't yet to determine how you're going to track this if you're going to change anything significant in your policy. Now we know for full-time employees, I'm eligible for 40 hours or 56 hours, but what about part-time employees? Is there anybody other than full-time employees? There are no exemptions in the policies for employees who are part-time, per diem, temporary, seasonal, students, interns, whatever you want to call them. If they are employees as defined by the labor law, if you're giving them a W-2 at the end of the year, they are employees and they are entitled to accumulate 1 hour for every 30 hours worked. Now, part-time employees aren't eligible for 40 hours, right? They're eligible for whatever they accrue at this rate of 1 hour per 30 hours worked. Maybe they do accrue 40 hours based on hours worked, but that's not a minimum, that's a maximum we're required to provide, okay? So part-time, per diem, temp, whatever you call them, if they are your employees, you have to set up a way to accrue and let them use sick time. So you're gonna have students come work for you for the summer who are gonna accrue, say they work full-time, they might accrue an hour of sick leave in their very first week working for you. And as of today, without the guidance of the DOL, they'd be able to use that time, let's say in the following week, they'd be able to use that additional hour. You can front load paid sick leave, as we said. That seems pretty clear cut for full-time, for exempt employees. You're gonna say, all right, we're obligated to give you 40 or 56 hours. We're gonna give you that up front. Part-time employees, you could come up with a system. You could say, based on your hours worked last year, we will front load you sick leave based on that 1 hour for every 30 hours worked, or however you want to do it. Front load that on 2021 and let them use that right away. You can see the difficulties of that. You people are a lot smarter than me at setting up these systems. But I could see a scenario where maybe we get to September and this employee maybe has worked more hours than we thought, and the accrual hasn't kept up with the 1 hour for every 30 hours worked. I'd hate to fall behind and have someone not have the leave they're entitled to because we decided to front load. So that's going to have to be a decision you as an organization come up with, whether you have the ability to accrue time or if you need to front load it based on your capabilities within your payroll system. The question we get most often is, I have a paid time off plan. We got rid of sick, we got rid of vacation and personal days, and we put it all into one big pot, and we don't care what they use the time for. Does that matter? What do I have to do? And I offer 80 hours a year, so I'm over the thresholds. Do I have to do anything different? I think your policy needs to be rewritten still, needs to be modified. You may have to modify it for the accrual and system. A lot of these policies say that we give you 80 hours a year. After you've been here 90 days, you're eligible to use this time. I think it's pretty clear from the statute that going forward in 2021, employees will be able to use this time as soon as they accrue it. There's nothing in the statute that provides that employees have to wait for a certain probation period or introductory period or whatever you call it to lapse before they can use this time. So I think that might have to be a modification in your PTO policy. You're going to have to make sure carryover provisions are met, right? That if you don't allow carryover in your PTO plan from 1 year to the next, you're going to have to allow that going forward. I want to go back because I think I might have missed something. I did. Before I go forward, I want to talk about carrying over. Unused sick leave shall carry over from 1 year to the next year, right? But we can limit the amount of leave that an individual uses in each calendar year. So if I'm an employee and I'm entitled to 40 hours of paid sick leave, I don't use any in 2021, I carry all 40 hours over into 2022. I start accruing, I get a bank of 60 hours or so. As an employer, we can limit them to 40 hours of paid sick leave. You can do something more generous if you like, but you can limit them to 40 hours of use per year. So when we're doing our carryover and our definitions in our plan, make sure we make that clear. What can we use this time for as we get these banks that exceed the minimum amount? And it's fine. You might allow employees to carry over more than, or to use more than 40 hours in a week if that's your threshold. But you have to define how that can be used and under what conditions. I would use the definitions and terms found in the statute, including explicitly listing the uses of leave found in the statute. I talked in my bullet earlier about sexual offenses, stalking, human trafficking. The statute goes into a little more detail and includes things like to obtain services from a domestic violence shelter, rape crisis center, to participate in safety planning, to meet with an attorney or other social services, to file a complaint or domestic incident report with law enforcement, to meet with the district attorney's office, to enroll children in a new school as a result of stalking or domestic violence, or to take any other measures necessary to ensure the health or safety of the employee's family member, or to protect those who associate or work with the employee. So you could have an employee where there's a stalking situation that might put their coworkers at risk. This employee can go meet with law enforcement to get restraining orders and things as a result of that. I think we need to include some or all of these definitions in our PTO policy. So if you already have a plan written, this is another revision that I think you're going to need. I think certainly we need to explicitly prohibit discrimination, harassment, and retaliation for employees exercising their right under their statute. I guarantee you, your paid time off plan, your vacation plan, your sick leave plans, whatever you have now, doesn't have a clause prohibiting harassment for using this leave as it's written in your policy. We need to explicitly state that in our new policy. One of my favorite examples of this is in New York City, and this is what I think will come from the guidance. In New York City, there's the Bloomberg News Corporation, big company, provides unlimited sick leave. Take as much as you want, anytime you want, no questions asked. However, if you're absent for more than 3 days, you need to provide us a doctor's note or documentation as to why you're out. The Division of Consumer Affairs in New York City that enforces the New York City sick leave plan said that that was harassing and intimidating to employees, requiring that a note be provided, interfered with employees' abilities to exercise their rights under the statute, and the Bloomberg Corporation paid a significant fine. I would think that in the guidance we get from the DOL, if we ever get it, will include some expansion on harassment and intimidating employees for using this, exercising their rights under the statute. Coordinate with other leave policies. If you require employees to use paid time off for FMLA reasons, let's make sure that whatever our use and accrual information jives with what we require for other leave policies. Paid family leave, you're going to offer employees the ability to use benefit time to supplement their PFL checks. Make sure that it all jives together. So when we have to make this change to our PTO policy, let's make sure we can it all jives with all the other policies we have. We'll talk about collective bargaining agreements specifically in a second. Some other considerations, we have to pay employees at their regular rate of pay. This is Section 196B of the labor law, and there is no definition of regular rate in Section 196, but in Section 190, it describes what regular rate is, and it includes shift differentials, commissions, essentially all other compensation you're paying this employee as a result of performing work for you. You may have individuals who are going to be paid sick leave at different rates at different times when they take it. Again, guidance will clarify this for us. Can I take corrective action due to absenteeism? So I offer a paid time off program. I offer 80 hours of paid time off, and this individual employee calls in without notice, short notice, 10 times by June 1st next year. So we have some concerns, right? This employee is not very reliable. Maybe we want to start some corrective action due to their unscheduled absences, right? PTO plans are great, but unscheduled absences are a burden to the employer, and we want to put some sort of, limit on those and try to correct this behavior. If that 10th absence is for a reason that's protected by law under the statute, I would argue we're prohibited from taking corrective action based on that. We can't discipline employees for taking paid family leave or workers' comp or disability, right? For those absences, this paid sick leave is going to fall into that category of job protected leave, and to take corrective action due to absenteeism for that could, I think, violate those employees' rights. So what does that mean? For paid time off plans, we don't ask the reason why, right? I think we're going to have to start to pay attention why employees aren't at work. I hope we don't go back to the system of having to do vacation and sick and personal days all separate. Again, you guys are way smarter than me at this. If you can develop a PTO program that lumps those all together, but still does some sort of tracking as to the reason why, we can blame it on the state. We can say, look, this new plan requires us to keep track. If your reason was due to A, B, C, D, and list them, we need to know. We don't need to know details. We just need to know, so that we can do our accurate record keeping. Similarly, attendance bonuses. The Business Council has a world famous $200 bonus if you don't miss any sick time during the course of the year. If I were to miss one day, and that day was for one of these job protected reasons, I could argue that this is job protected leave and this is a $200 penalty for me taking that leave, and would be inappropriate. And I think the Department of Labor would agree with me. Again, hopefully guidance will clarify some of this, but if you do attendance bonuses, that type of incentive, be aware that it may be impacted by this new paid sick leave program. Can I mandate they use paid time off before they use paid sick leave? I don't think so. I think this is going to be, again, like a paid family leave situation where an employee gets to designate the type of leave they're taking. Again, hopefully these can be integrated and we don't have that distinction between these two plans, but if you do keep them separate, employees are going to be able to decide that it was for a job protected reason or not. So again, documentation, I think, is going to be the challenge, right? How do we keep track of the accrual process, the leaves that employees take, and have it ready for them to, upon 3 days notice, to give to them in writing. Can we require employees notice before use? Not likely. Again, it doesn't say specifically, but I would think with the standard now is that as soon as practicable, employees can call in and exercise their rights under the paid sick leave plan. So if you have policies that say we will pay sick leave if you call in 2 hours before your shift begins, I think we need to remove that 2-hour threshold and say use terms like as soon as practicable. Can we require medical documentation from the employee? Again, I gave the example of Bloomberg News where that requirement in and of itself has been interpreted to be harassing and intimidating to employees. I also think there's going to be scenarios where we as employers don't want documentation, right? If someone's spouse or family member was a victim of sexual assault or domestic violence, we don't necessarily want to collect documentation of that. Let's maybe take their word for it if they claim that's the scenario. If you have a good faith reason to believe that a fraud is being perpetrated on you, then you can push for more, but I would imagine that would be pretty rare. The good news in the statute is that the person accused of domestic violence and stalking, if that happens to be your employee, is not entitled to this paid sick leave. So if you are employing the stalker or the abuser, they are not eligible for this benefit. But requiring documentation from employees, supporting documentation, I would say at this point is not recommended, and I would think the guidance is going to explicitly prohibit employers from digging for too much information. Collective bargaining agreements, here's an area where guidance is desperately needed, and I'm going to refer you to your labor attorney. This is the totality of the discussion of collective bargaining agreements. I cut and pasted it and put it on this slide. Nothing shall prohibit a collective bargaining agreement entered into after September 30th to have comparable benefit in lieu of the leave provided for in this section. So you can come up with a different sick leave program in your collective bargaining agreement, those entered into after 9/30/20. As long as, and you go down to the third bullet, you must specifically acknowledge the provisions of this section. So I think, again, in your collective bargaining agreements, you're going to say, all right, well, we negotiated a paid sick leave that provides comparable benefits. I think in that agreement, you're going to have to define reasons for use and the non-discrimination language as well, and acknowledge the other provisions of the new statute. But again, what happens if my collective bargaining agreement is in effect now and it won't expire for 2 more years and it doesn't provide the minimum 40 hours or 56 hours as required by the statute for 2021? I don't know what to tell you. There's no answer for that question at this moment. Again, consult your labor attorney, and let's wait for guidance from the DOL. Hopefully there'll be something there about this transition period between contracts. And that is all I have for slides. My contact information is on here. I know the intention now is to take some questions. I see there are some in the Q&A box. Rebecca, how do you want to do that? Do you want me to just go through and read them, or?
I can give them to you. So thanks
All
so
right.
much, Frank. That was wonderful. So there's a bunch of questions here. There's some repeats, but I will just read them as they're written. So how will this? I have about 35 exempt employees in my organization. If I choose the accrual method and not front load it, do they have to accrue 1 hour per 30 hours worked? So those exempt employees, are they also on that 30-hour accrual?
Yeah, the statute makes no distinction between exempt and non-exempt employees, right? It just says employees. So everyone accrues. If you're going to do the minimum amount that the statute requires, you have to, and you're going to use the accrual system, then that minimum accrual is 1 hour for every 30 hours worked. For exempt employees, their actual hours worked fluctuates from week to week, right? Again, we work a 37.5 hour work week here at the Business Council, but I work hundreds of hours a week if my boss is listening. So does that mean I accrue at a greater rate than some of my slacker coworkers who don't work 100 hours a week? That's going to be an organizational decision, but I would think probably the most common method is going to be exempt employees are going to accrue X number of hours per week based on their normally scheduled hours worked.
Okay. How about, can you have a PTO policy for part-time employees and a different PTO for full-time employees?
Yeah, you can make distinctions based on class of employees, right? Full-time or part-time. But both groups are going to have the same minimum accrual level, the same reasons for use, the same ability to carry over. So they're going to be very similar, those policies. I can maybe imagine you might come up with a couple of other reasons you would give exempt employees additional flexibility on that time. But you're not going to be able to restrict part-time employees from using their time as it accrues, and you're not going to be able to affect their accrual rate. So you can have different policies because you can discriminate in your policies just as long as you don't discriminate based on age, race, sex, creed, color, national origin. But you can discriminate between full-time and part-time, exempt and non-exempt. We have executives who earn greater vacation and time than other employees. So we do it all the time. You can have different policies, but you have to meet the minimum requirements of the statute.
Okay, thank you. Our employees plus hours start off with 3.5 hours weeks of PTO. We do not have a current sick leave policy. Would our PTO plan be equal to or exceed the requirements of the New York sick laws?
I think you need to change it because all employees, even those who work less than 20 hours a week, are going to accrue paid sick leave or paid time off, whatever you want to call it. If you don't have a current sick leave policy in place, I used to be a fan back in the old days 100 years ago when I graduated college, that we didn't always put things down on writing, right? It's good to have a sick leave policy, maybe that's not in writing. We have a little bit of flexibility in applying it, only constrained by our past practice. Those days are gone. You have to have a written down on paper, distributed to employees, paid sick leave policy. So you're going to have to change your policy in your situation for a couple of reasons. One, you need it written down, and one, those who work less than 20 hours are going to be eligible for benefits.
Can employees accrue more than 56 hours, or is 56 hours the max?
Nope, you can have a more generous plan if you like. These are the minimums. These are the minimum amounts you're required to provide as an employer. So go for it. Provide more if you want.
All right. Would you suggest that detailed wording that you talked about be listed in the handbook as well as, or just have the handbook say simply refer to the policy?
Handbooks can be tough to update because you spend a lot of money and you bind them and they're really nice looking and things like that. If you have a paid time off policy that has some complexity to it, it's going to take more than a couple paragraphs. Yeah, keep it as a separate policy, and in your handbook just say, we provide paid time off to employees. Please refer to the policy. You can get it from your manager, whoever. That saves you from having to reprint your handbook as often because you can just change the individual policy from time to time. But everybody does you don't have to have a handbook, right? You can do just a policy if that's where you're at in your organization. But yeah, you have options on how to do that. But I think it needs to be in writing somewhere that they have access to it.
So this company gives all of their full-time staff and salaried employees six excused absence days, but there's a portion of their staff, attorneys, who are not given a set amount of time. Do those attorneys now need to be given a set amount of time? If
those attorneys are employees, you might avoid that by making them maybe their owners. But if they're employees and paid a salary and get a W-2, they're entitled to paid sick leave. But I know there are some, organizational structures where those individuals might not be employees as defined by law. But if they're subject to minimum wage, paid family leave, all those other things, workers' comp, disability, then they're subject to paid sick leave and should be accruing and getting it.
Do you have do you have advice for employers that are already offering unlimited sick leave policies?
I get unlimited sick leave. I think it's great that you provide that kind of flexibility, because I assume you're able to use it for things like, supplementing my DBL payments if I'm sick, or helping a family member who has a serious health condition. That's great. Again, my feeling is always that when something gets mandated on us by the government, I get a little less generous. Maybe that's not the right term, but I get a little more restrictive in how I want it applied. So unlimited is great. I would limit how much they could use per year of the job protected sick leave. Remember, not all other sick leave is protected. What you offer now is not protected leave. If an employee is abusing your sick leave policy, you reserve the right to fire them, right? Well, going forward, starting next year, 40 hours or 56 of that hours is job protected leave. So I think, yeah, unlimited is great, but I would make people aware that it's not all job protected, but some is.
Next one. If I start accruing hours on 9/30, do I have to have all 40 hours accrued for every employee by 1/1?
Nope. They accrue what they accrue. It is what it is. Again, I think there'll be some guidance about this for full-time employees, right? Because they'll have a few hours when they get to January 1st. And then if you want to front load, on January 1st, what do? We take out the hours they accrued from, they don't get September to December hours and then front load something else. So I think there's going to be some guidance on the mechanism of that. But nope, they accrue then and can start using January 1st.
Okay. Is time accrued only on regular hours worked, or will overtime hours be counted when calculating?
Just says hours worked. So if they're working an hour, it's considered an hour work. They'll be accruing paid time off or paid sick leave for that.
Can an employee use paid sick leave for an annual doctor's appointment?
Yes, clearly within the reason listed in the statute. And their family members, their grandchildren, their grandparents, their spouse, their dependent children, if they have doctor's appointments, you'll be able to use it for that.
How about this one? Would an employee be able to take a trip and use the time off as mental health days?
That's pushing it. The frustrating part is that this is job protected leave, and we probably can't request medical documentation, and then they put it on Facebook, right? Because employees don't set their accounts to private, or they friend their coworkers. And then we find out about it. How are we going to deal with it? It talks about mental and physical illnesses and injuries. So if you think they're just scamming you, then say, okay, if it's for mental health day, can we get documentation from your mental health provider that this was required? You could ask, and then maybe that gets the point across, whether it's ever produced or not.
Sure. How about this one? When determining your employee count to determine what you need to offer, what period of time do you look at? Is there any sort of clarification on that, as this company's employee count is very different this year than other years?
It does, and it's in the statute specifically, which is unusual. They don't always define in the statute, but it says a calendar, for the purposes, it's the 12-month period from January 1st through December 31st. The regular, let's see, we get to pick the 12-month period, but for this year, it'll be January 1st to 31st. The average number of employees you have employed in that year, and that'll apply for the next year. So if we had 100 employees last year, on average, we're providing 56 hours for the next year, regardless of how we fluctuate that year.
Can you allow unused sick time to roll over to the next year as PTO, or does it have to roll as sick time?
This goes to the record keeping requirements. You have to let them roll that over. But if you call it PTO, but it has the effect of being paid sick leave, you know what I mean? We call it PTO, but in reality, it's job protected. It can be used for those reasons. Fine, you can call it PTO, as long as it can be used and accessed according to the statute. It's less important what you call it, as opposed to how you treat it when it's used.
Sure. Can we track the sick leave accrual on a bi-weekly basis for employees paid on a bi-weekly basis?
Well, yeah, I think I'm trying to think how that, your payroll system works. The danger is that someone becomes eligible for an hour of paid sick leave during the pay period, wants to use it, and you say no. And you say, well, why not? Well, according, the payroll period ends next Friday. And I won't know if you have it then. Well, I have it. You just aren't letting me use it. So the employee could be denied payroll. So yeah, I think it can. I think you can use a bi-weekly accrual system, but just be sensitive to that when someone applies to use it, that it's not, the statute's silent on that, right? They don't care about bi-weekly or weekly. You accrue 1 hour for every 30 hours worked. So people are going to accrue leave in the middle of your payroll system, payroll period. Just make sure you don't deny them something that they're entitled to just because it didn't fit with your pay period.
Okay. If someone calls off for 3 days and we can't request documentation, how do we ensure the person is cleared to return to work?
That's an example from New York City. So it's not the law that we can't ask for medical documentation. I would always ask for medical documentation, especially if we suspect it's for a serious health condition, right? Because we have FMLA concerns, we might have ADA concerns. So if we have a good faith reason to believe that this is an illness that needs attention, I would ask for documentation. Now, the guidance could come out at noon today, which it probably will, right? The guidance will come out at some point and say we can never ask. Well, if that's the case, then we can never ask. But as of right now, I'm not going to rely on the Bloomberg example to stop me from asking for documentation.
Okay. We front load our time. What's the minimum amount of time that we can allow to roll over?
We front load our time. Well, all time has to be able to be rolled over. All unused sick time. Trying to see where we're going with that. So if an employee has paid sick leave left over from the previous year, all of that rolls over to the next year. Then you're going to front load an additional amount based on whatever calculation you're going to use. That would be added to whatever is rolled over. So I think that might be where they were going with that. If not, ask us again.
So to clarify, regular full-time employees are accruing 1 hour for every 30 hours worked up to a max of 40 to 56 hours.
That is the minimum requirement. Right?
We currently do anniversary year, so some already have 24 hours that have not been used. Do we front load that 24 hours and let the rest of the 40-hour accrue?
That'll be up to you. We're in a transition period here, and the guidance is quiet on what we do with our 2020 sick leave plan, right? Since no sick leave was required in 2020, we have all sorts of flexibility in the rules that were written. Now 2021 is upon us, and hey, employees, there's a new paid sick leave plan that's mandated. Here's what we're going to do. And you have to do what you think is fair, what employees will be perceived as fair, right? To try to transition to this. But what happens in 2020 is in your purview, except for the accrual starts in a couple of weeks. So how you transition, you're going to have some flexibility on how you transition.
Okay. We front load 80 hours PTO. What if an employee takes all available PTO hours for vacation? Do we need to provide additional time for medical reasons?
Yeah, I think that'll be a challenge we have going forward, right? Because now an employee took their 2 weeks for vacation, they come back. Now they have a legitimate job protected reason under the statute to take additional leave.
Yeah.
I think the guides, I think we're going to be on the hook for paying it.
Yeah.
And that's why I fear that this is going to push us back to separating vacation, sick, and personal.
Yeah.
I would hope the guidance addresses that question. We've already posed that question to the department,
Right.
Because there's no obligation we provide additional time off in the statute, but I think they're going to interpret it that way.
Are New York State employees exempt from this benefit?
Yes, this only applies to private sector employers. Does not include the state or municipalities.
Can employers specify when carryover hours have to be used by?
So the job protected leave was carried over. You want to put a deadline on that? No, I don't think so. Again, we can put a maximum annual usage amount on them. But I don't think we can put a date that says, the sick leave that was going to expire on 12/31, well, now it's going to expire on 6/31. The following year. I don't think that would be permitted.
Okay. This is along the same lines. What's the purpose of the rollover requirement if the max usage is 40 hours?
Yeah, good question. It seems a little contradictory that we'll let you carry it over, but cap what you use. I think it was to give employees the perception that they're not losing anything. And I don't think most employees are going to be carrying over their full amount. I think they anticipated that employees are going to use this time. And if I got 5 hours left, I'll carry over 5 hours.
I think we have time for a couple more. We have, if a company has multiple entities, maybe most are under 100, but overall they're over 100. Is there guidance on determining that size?
There is not in the statute. So I'm thinking now about other provisions in the law where this is addressed. And I think the most recent one might be paid family leave. No, maybe not. Good question. I'll have to find out if there's any, again, the statute's silent on that. So my hunch is they assume it's defined in another statute. I'll just have to find which one they're thinking about.
Okay.
I'll make a note of that.
Okay, great, thanks. Should we wait to amend our policies until the guidelines come out? Until then, should we notify our employees that a change will be coming on January 1st? This is a
yeah. All summer long, I've been telling people, don't change your policy. Wait for the guidance to come out. It'll be coming out any day now. And now, we're way past that. Boy, give it till tomorrow. One more day. That's my fear is that employees, you have a good handle on this. You address your policy, you rewrite it, and then the guidance comes out next week, and there's 2 or 3 things you have to change again. Clearly we could do the best we can, get our policy as good as we can, and just tell employees, look, we're doing the best we can. We're based on the statute. This is what our policy is going to be. There may be changes coming as the Department of Labor provides us with new regulations or guidance. That's all you can do.
Okay. If an employee calls off for sick every Monday after a home Bills game and they're within their 40 hours, can they be disciplined?
No. Job protected leave, right? I mean, within the restrictions they put on us for asking for medical documentation. Now, doesn't mean I wouldn't talk to that employee. I'd say, what's going on? You're sick every Monday after the Bills games. Is this something you need to see a doctor about? Something like that. But I don't think, and I would document this as an employer, but I don't think we can discipline or dock their pay or refuse to pay them their time for that. It's job protected.
We give our employees 6 days off, 48 hours on 1/1. If an employee does not use all of their time, they can roll 40 hours to the next year. Now they could have 80 hours of sick time. Can we limit how much time can be carried over?
I'm assuming you have less than 100 employees and 40 hours is your minimum obligation. So you give 48 hours at the beginning of the year. That sounds as if it would meet, as long as you talk about the accrual, use, and carryover reasons. You've met the standard. And you allow them to roll over 40 hours, which is the max anyone could get under the minimum amount you're required to give. You should be okay. Can we limit how much time can be carried over? As long as the limit is above your 40-hour threshold, right? You couldn't limit 20 hours, but you could limit it to 41 or something like that. Okay. Hope that helps.
I think there's some confusion on this. So this is another one I just got. So giving them minimum of 40 hours and limiting to 40 use, is there a possibility that employees can have a carryover amount of 120 hours in 3 years since they never used them, but can only use 40 hour in the year they need?
Correct. Right. Employees who are given this 40 hours every year and never use it can carry over from year to year and accumulate a big bank of time. And that's why you want to put restrictions on how it can be used. In your policy, you could say 40 hours can be used for your personal illness, blah, 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 as defined in the statute. The other 80 I've earned, I don't know. We'll limit that to use to supplementing disability absences if you want, or don't say anything about it. You don't have to let them do that. It's only the additional 40 hours max that you're going to focus on restricting their use. But yeah, you could have employees who accrue banks, and you know, it's one of those things in the law that's like, well, why did they write it this way? I don't know. It's just how it got written.
Do we have to notify employees prior to January 1st of the legislation?
Yeah, you know, there's no notification requirement in the statute, which is ridiculous, right? So you know they're going to come up with something to where we have to notify employees of their rights. My hunch is the Department of Labor thinks, you know what, employees can't use this till January 1st. Anyway, we got a lot of time to come up with guidance. Yeah, sure, accruals can start on 9/30, but they can always do that retro. So we're in no rush to do this. I think the guidance will have some sort of employee notification requirement about the new, you know, New York City has one. There's a poster, and you have on the first year, you have to give them a summary of their hours and all this stuff. I'm sure our New York City-based attorneys at the DOL will come up with something similar.
Does the rollover date have to be January 1st, or can it be date of hire or a different date?
You know, right. Yeah, no, it can be date. You can pick anniversary years. You can pick a 12-month period as defined by the employer. You know, because you're going to hire people next February 1st, right? And they're going to be accruing and eligible for time. So you'll be able to do that as long as they can carry over according to the statute.
Okay, so I think we have just a couple more. So student stipend employees have historically not been counted as legal employees because they're paid a flat rate regardless of whether they work any hours or not. Do they still need to accrue paid leave hours for those students, or just for salaried and hourly employees? And if so, how would that be tracked?
Stipend students who I wouldn't consider them, they probably don't meet the definition of employee under New York State labor law, right? They could be interns or some other independent contractor, some other non-W-2 type employee. I know that they exist in the academic world. If they're not an employee, then they don't accrue the paid sick leave. I always get nervous though, because I get these questions quite frequently, and oftentimes they are misclassified as stipend employees when really they are and stipend students when reality they are employees. So assuming they are correctly
W-2, she said.
I'm sorry?
They do still receive a W-2, she just said.
Then they're going to be employees under the New York State Department of Labor for the purposes of paid sick leave, and will have to accrue and use sick leave.
Okay, looks like most of the questions in here are repeats, so I appreciate your time. I don't want to take up too much more.
Sure.
I'm going to pass it to Chris. Thanks, Frank.
Sure.
Thanks, Frank. We appreciate that. It was a great lot to learn here, and I think there's still a lot of unanswered questions is kind of some of the takeaway here, but I do believe, I think folks here got a little bit of direction, because at the end, we probably have to proceed and operate with the, using our best judgment on how this law is going to work itself through, even though we might not have guidance. Again, thank you, and just want to let everybody know that Walsh Duffield will be, we do these webinars for our clients and for our friends on a regular basis. The next one is scheduled for September 24th. That one, the title is going to be The Loss of Normalcy, Dealing with Many Faces of Grief and Isolation in This New but Temporary World. And it's going to be hosted by the Walsh Duffield Wellness Team, and also the former executive director of Mental Health Advocates of Western New York. If you'd like to, we will be sending out an invitation. We might have already done that, so you might have already been invited, but you could visit us on the website we've got shown here, walshstuffield.com/webinar. If any folks have any questions that might not have been answered, please direct them to us. Anybody on the Walsh Stuffield team, we'll see if we can't find any specific answers for you. And again, Frank, thank you very much. Rebecca, thank you. And we hope everybody has a great day and a great week. Take care.